Bismillahirrahmanirrahim. I begin in the name of Allah, whose grace, guidance and mercy we seek in this and all matters. Blessings and salutations on our noble Prophet Muhammad sallallahu alaihi wasallam, his family, his companions and all those who follow him. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to Get Real with Islamic Care Line, a program on ITV, which is a series that we're doing in terms of tackling the taboo in our community. The topic today is on divorce, mediation, custody and access to children. My very special guest today is Tasneem Musa, who is a practicing attorney and has over 20 years of experience working in family law, and hopefully she's going to spend some of her time with us explaining the process of divorce, the litigation process, and everything else that goes with it, so that viewers can be clearer on what is happening to them if they're going through a process like this. Tasneem, welcome, and thanks for your time. One of the reasons why I thought it was very important to discuss this is that in my experience working with dysfunctional families and marriages the last 28 odd years, there seems to be a trend that is moving more towards a litigation process for divorce rather than just a breaking of the nikah, right? Many more spouses, many more couples are opting to also have the legal divorce contracted. But like I said, when a couple go through a difficult time and they decide to divorce, then again, in my experience, everybody in the family becomes a lawyer and everybody is advising the couple. In terms of that, do you want to just please explain to the viewers just a normal litigation process for divorce?
Well, the litigation process is made up of, you can do it in two ways. You either have an opposed divorce or you have an unopposed divorce.
Okay.
An unopposed divorce is usually where the parties have come to some kind of a settlement.
Okay.
There's a settlement agreement.
Out of the legal process.
It is part of the legal process.
Yeah. Okay.
What happens is the parties come to a settlement agreement. They circumvent all the fighting.
Okay.
They agree on maintenance. They agree on custody. They agree on the propriety of the dissolution of the estate. And that is encompassed in a settlement agreement.
Okay.
They come to a lawyer and we set the matter down in court and a court order is made.
Okay.
It's the easiest, fastest, cheapest way of doing things. It's good on you emotionally, psychologically.
Yeah.
So that's the best, that's the fastest way of doing it.
Okay, that's the unopposed,
That's
right?
the unopposed one. The difficult one is the opposed divorce.
Okay.
This happens where parties decide, well, they're now going to get divorced. They've tried everything in terms of reconciliation, counseling, etc. They now come to a lawyer and they decide they are going to fight this thing for whatever reason they're going to fight it. When that happens, we then institute action. That means we issue a summons.
Okay.
In the summons is the notice to the other party, telling the other party that I, or the plaintiff, the party who is instituting action, intends to institute action, file for divorce. And attached to that summons is a document called a particulars of claim.
Okay.
Now, in that particulars of claim, in layman's terms, it says, this is who I am, this is who you are, this is who our children are, this is what you and I own, this is how you and I have been married, this is what we own, this is how I want to deal with custody and access of the children.
That's all in the first.
It's all in this particulars of claim. It says, it sets out the
and
whole
let me
divorce
just
process.
go a step back. Obviously then, in an opposed divorce, the couple will have different lawyers. Okay.
not necessarily. The instituting party usually has a lawyer. However, the defending party could defend themselves.
Oh, okay.
So you don't necessarily need a lawyer,
okay.
although it is
In
wise
your favor,
in your favor
yeah,
to get
absolutely.
somebody who understands
and that's
the
the
system.
other thing, as an aside to this program, to this topic, we have professionals in our community, and they are there for a reason. I don't see any value in not using lawyers when you need to, because the advice is immeasurable, and the way forward and the support in many ways also helps. Okay.
So once in that document you have, how you're going to have access, how you're going to how the access requirements are going to be dictated, what you're going to do with the proprietary aspects. That means the assets between the parties, and also how maintenance will be dealt with.
Okay.
Maintenance for the children, maintenance for the spouse.
Okay.
All of that is listed in there, and the defending party is given 20 days within which to respond to this.
Okay.
In which time the defendant, who is the defending party, will then respond and enter an appearance to defend.
Okay.
And once that happens, the process then starts.
Okay. What is the process? And the reason why I'm asking this is that, again, in my experience at Islamic Care Line, Allah in His wisdom has made recourse to a separation and divorce possible. Although we know it's the most hated act, most abhorred act, and we know of statements that thrown off the arsh of Allah shakes at the mention of a divorce and things like that. But the reality, and without taking anything away from the Sharia aspect of it, the reality is that divorces do happen, okay? And more so, as I said, again, in my experience, there's an increase in the number of divorces in our community, unfortunately. But Islam also says that you have recourse to divorce, but it doesn't have to be ugly. It does not have to be acrimonious, okay? And we spoke earlier today as well, and we agreed that the acrimony is very often not about the money. It's about the getting back at each other. And so maybe, I don't know if you want to go into that a bit later, but what I want to ask is that, do you find that today with a lot of couples that are approaching lawyers or the legal system for divorce, that it's becoming a very unpleasant experience? And the next part to that question is, does it always have to be that way?
To answer the question about it being an unpleasant experience, speaking from a litigation point of view, I have found that parties use the litigation process as a means to unpack their troubles and their psychological issues and their financial issues and their emotional issues with their respective parties. They use the litigation process for that. They are aided and abated by a neutral arbitrator in the form of a lawyer who then helps them to perpetuate the abuse. So it may seem like an abuse, but what they're doing is this lawyer is helping them, and they're having that opportunity to unpack their troubles. So as opposed to doing it in the form of mediation, often by the time people have come to us, they have tried mediation. And the mediation is usually done by a family member or an elder. Now, the mediation is often biased or very dilatory in nature, not getting any quick results. So they come to you. And when that happens, they still haven't dealt with their issues. They haven't had counseling or anything, so the litigation process is used for that. And that's why it becomes so acrimonious and all that, because they haven't worked out their stuff.
Because I just think, time and time again, in cases like this that present to the care line, and we try the counseling and so on and so forth. And eventually, look, it's the couple's prerogative to say whether they want to be together, stay together, or divorce, and oftentimes it goes to a divorce and a whole litigation process and that. But for me, sometimes the demands, and as you rightly said, people unpack their own baggage during this litigation process. The demands are unrealistic in terms of financial aid or care that they need. Very often, a woman who has given her life to this marriage, the better part of her working life to her marriage, she may be professional or not, but she hasn't worked, and so she's not even able to enter the market again, because we know after the 3 months of her talaq, he needs to maintain her, even Islamically, for the 3 months at least of her talaq. Even that doesn't happen, and I want to talk a little bit about maintenance as well. But she has no way in which she can re-enter the workplace. So things like rehabilitative maintenance, right, where he needs to support her enough to upskill herself so that she can go and start earning her own living, even not even for the children, which he's supposed to be responsible for, depending on their ages, of course, but for herself. She needs to still do something. She needs to have a life, right? And why do you think these sort of issues are not made relevant in divorces today, or are they?
No, they are made very relevant.
Okay.
I'm not speaking from an Islamic point of view. I'm speaking strictly from a secular point of view. If a woman has spent 30 years of her life enabling a man to build his career, looked after his family and his home, she is entitled to some kind of,
reimbursement or recompense,
I don't know if it's called compensation.
Yeah.
But she's entitled to her share of the booty, so to speak. In terms of South African law, if you married, it also depends on how you were married. I think perhaps you should step back a little bit. Yeah. Because there's different ways. You are either married in community of property.
Maybe just mention that, because I think that's important for the viewers to know the difference.
Yes, you're either married in community of property, where that really means that you have what's yours is mine and mine is yours.
Yeah.
You share equally in each other's estates, or you're married by antenuptial contract with accrual. That means you each have your separate estates.
Right.
But whatever you accrued during the course of your marriage, it's akin to marriage in community of property.
Yes.
The Islamic way of doing things is to have it completely by ANC, where your estate is yours and mine is mine.
Yes.
So having regard to the various matrimonial regimes that we have, that then dictates how the estate is dissolved eventually.
Okay.
But to come back to your question on rehabilitative maintenance, even if there was an antenuptial contract, there is, if a woman can prove that she, it doesn't take rocket scientists to work that one out. If you spent looking after 5 or 6 children and you did nothing else, and the man, and you work there. I had a case where I had a particular lady who had spent the first 10 years of their marriage working. She had 4 children in that time, supported her husband while he was studying to become a professional. And the agreement was that when he qualified, she would then take a back seat and he would take responsibility for the home. He eventually became a high-flying professional. Yeah. And the marriage then ultimately got dissolved. And when that happened, he completely forgot. And in that time, she had lost all her chances of, employment abilities because she had not worked for about 15, 20 years. So there was a classic case for rehabilitative maintenance. It was a classic case for, a dissolution, even though they were only married Islamically in this case here. She got 50% of the estate because we could prove that, if nothing else, there was a universal partnership.
Okay. All right. I think we need to go for a short little break, and when we return, we'll be back again talking about maintenance, access to children and custody. Thank you. We'll be back after this. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Get Real with Islamic Care Line. This is a series of programs on ITV. Today our topic is on divorce, maintenance, custody and access. And my very special guest is Tasneem Musa, who's a lawyer and is very well experienced in family law and has worked with many Muslim couples. Welcome back, Tasneem. I know we have so much to discuss because the topic is so wide. I want your take on maintenance and how it works, because again, I think community members don't have the right perception of what maintenance actually is and how it should work. So briefly, tell us about maintenance. So when a divorce takes place, then obviously maintenance kicks in, right?
I think if there's any unrealistic expectations on maintenance, that's usually linked to the anger issues that parties have with each other. Yeah. But you know, once maintenance, there's a formula to calculate this.
Okay.
There's a formula in which you calculate it. It isn't something that you can
just ad hoc.
You can just add hoc and put a number to something. You've got to take into consideration a person's earning capacity, both the spouses' earning capacity. Look at their individual expenses.
Yes.
You've got to look at, if there's children, you've got to look at what the children's expenses are. And there's a rule that says that, you know what, when you're paying maintenance, your children are your first creditors.
Okay. So
your children's responsibilities and the expenses in relation to your children need to be considered first.
Yes.
So as I said, there's a formula. You know, there's a list of expenses. You minus the expenses. You look at the disposable cash. You look at issues. You look at expenses which are not requirements.
Yes.
And advice is given to a client to tell them, look, you know what, this should be taken off your list because a judge will take this off your list.
Okay, okay.
So you explain that to them, and then then the law says that one should be kept in the same style that you were at the time of your marriage.
Or standard of living.
Same standard of living. But, you know, I mean, realistically, one has to consider that with a divorce, parties have new homes.
Yes.
They start new families. So expenses grow. So that is also taken into consideration. And ultimately, the maintenance is a very realistic figure.
Okay.
It's supported by vouchers. If you say you have a X amount grocery bill, well, then you should provide the vouchers. It should be commensurate to the people that live in a home.
Yes.
So all these things are checked very clearly.
Okay.
It's just not a thumbsuck.
Yeah. I think that's very important because oftentimes people are encouraged to ask for ridiculous amounts either way. And as you very rightly explained, there's a formula and it has a lot of contributory factors that would determine the amount in the end, right? I know in the care line also, what is happening more often is that we're getting the family courts or sometimes even private lawyers because women are going to them and saying that, you know what, my former husband, ex-husband is not paying or not continuing with the maintenance agreement. So there is that gratuitous maintenance which they expect us to get from the, if the clients are if the couple are our clients, and then they go through the divorce, very often it'll come back to us and say, you know what, we need to put a garnishing order for the husband to make sure that the maintenance is paid. Does that work, and how common is it?
Well, if you have a court order stating that somebody has to pay maintenance and maintenance is not paid, gets an opportunity, you can give him notice and have a man arrested for not doing that, you know?
Yeah.
Alternatively, you know, you have the option of going back to the maintenance courts.
Yeah.
and either increasing the maintenance or decreasing the, there's never a decrease
There's never
ever,
a decrease, yeah.
but to ask for an increase in maintenance or whatever. But somebody that, therein lies the problem often, you may have a man who was working all his life, and this is the kind of experiences that I have, is that after the dissolution of the marriage, when he stops paying maintenance, it's usually because he started another home, has more children, or alternately just has difficulties
coming up with a
the reason for the marriage may have been that he was a drug addict or something like that. So when parties institute action, there's a plaintiff and a defendant, one spouse and the other spouse. But where there are children involved in a marriage, then the state provides an attorney for the children in the form of the family advocate.
All right. Okay.
So when you institute an action, and there are children and there are who are minors still, you have to, apart from that particulars of claim that I spoke about, if there are minor children, you then fill in another form informing the family advocate that there is a divorce that's underway now. There are these children involved in the divorce. If you have an unopposed divorce and the parties have settled beautifully, you send what they call an annexure A to the divorce, to the family advocate, where you say, the parties have settled. This is how the children will be, this is who the children will stay with, who will have primary residence, who will have visitation rights, how the visitations will work. You put that all there. And that then gets taken to the family advocate's offices, and the family advocates will either endorse it, and usually they do if it's a settlement. Where there's acrimony between the parties, and and there's fighting about who should take the children and which weekend they should have them, and which holidays, or even where primary residence should vest. Then, or worse still, if there is a suggestion of abuse. Or there's a suggestion that the one party is not fit to be a parent to have access to this child. Then there is another form, it's called an annexure B. That's a form that is where the family advocate is asked to, in terms of this mediation in terms of certain divorces act. In terms of that act, the family advocate then intervenes, and the family advocate will then do a full investigation into the home circumstances, into any of the allegations that may prove to be, contentious between the parties. Often what is done is a social worker is called in. A social worker is called in to do the investigations. If the parties have the finances to do that, it's paid for privately also. It's paid for privately in the form of a social worker or a psychologist or an educational psychologist, someone who specializes in this kind of area of law. And then there are home visits done, there are personal visits done with the children in order to ascertain where children are best suited to whom they should be left with. Once this is done, a report is then prepared. When this report is prepared, this then ultimately becomes what you will take to court in a full litigation, or alternatively will be encompassed in a settlement agreement. It's then taken to the family advocate who is in charge of that particular matter. This will will be endorsed by the family advocate, because this would have been there would have been a complete clinical assessment. And it's not ideal to go that route, because what you're doing is you're letting a third party decide how your children are going to be dealt with. It's not ideal, but if you fight, that's what's going to happen. So the idea is that that parties should try as best as possible to leave their personal issues aside and focus on the important people in that whole thing, and the best interest of the children.
From what you're saying, obviously, if it becomes a fight, it's going to be a long process. Is there any way that the process can be expedited. What I'm thinking about here is, and I'm sure and I know that in no way have we exhausted any one of the topics, but it's only a half an hour program we have, and if need be, we can always look at scheduling another program of this nature. What I'm thinking about in terms of expediting the process is mediation, and my concern is that members of our community who are going through a divorce or a dissolution of marriage in any way are not taking advantage of the professionals that we have that are divorce mediators. Now, I know you mentioned earlier also, and we know Islamically and in our Muslim lifestyles, there's always family mediation going on the minute a problem hits a marriage and it comes to the fore. I'm talking about professional legal divorce mediation. I want you to just enlighten the viewers about the advantages of something like that.
In my view, I think that divorce mediation is the only way one should go. The litigation process is long. It's protracted.
Yes.
It's emotionally, psychologically, and financially exhausting.
Yes.
Mediation is with a qualified professional who is objective, who is not related to the parties, who has a legal training. Whilst it may be more expensive on the day,
Yes.
you know, because you
Long
have to
term,
pay the
it's
cost of the mediator, the cost of the report,
Yeah.
the cost of the full day or 2 days fees, but you are guaranteed that your mediation is going to happen within a specific time period. So you're going to decide. Parties can decide. We're
Yes.
going to have the mediation it's going to endure depending on how large estates are
Yes.
or how big the issues are.
Yeah.
We put a time frame to
Yes.
it. 1 week,
Yeah.
2
And
days.
within that time.
And then you need to finish in that
Yes.
time.
Yes.
One, it's done already. Secondly, a mediator is not going to allow you to unpack your personal
Yes.
troubles. You don't have that, and there's no delay.
Yeah.
There's no subterfuge. There's no litigation by ambush.
Yes.
There's none of those things
Yeah.
that's happening. It is in a very controlled environment.
Yes.
But the beauty of mediation is that you, as the parties, ultimately make the decisions.
The important decisions.
The mediator is just a facilitator.
Yeah.
But the decisions are ultimately made by you. You're not leaving your personal issues, your children's lives to be dictated by a complete stranger.
Yeah.
So
Absolutely.
I think mediation is the way to go.
I really feel that it is much underused. Maybe because people don't know about the process that much. But I think it really, and if anything, if this program just gets people thinking about what mediation is and where they can seek it or source it, I think we would have achieved a lot. Because I really think, as you say, and especially in the beginning, it may sound like a lot of outlay of money, expenses, but when you look at the protracted litigation process,
In the long term, it's just the
is
cheapest.
going towards, yes, it's cheap, most cost effective. I won't even call it cheapest. I'll say it's the most cost effective to do it.
It has nothing to do with money. It's got
has
everything to do with
with-
your divorce. By its very nature, is so emotionally destructive.
Yes.
And the cost to your emotion, there's no price
There's
to
no
that.
price.
The quicker you end that,
The quicker you can carry
quicker
on
you
with
can
your
carry
life,
on.
and a happy life
Yes.
at that, and a more settled life and a calmer place to be.
That's right.
What would you say as a final message to viewers about if they're going through a divorce? What would you say to them?
Leave your personal stuff aside. Focus on the issues. A perceived bad settlement is much better than a long, drawn-out, emotional, expensive litigation by a court order.
Okay, those are important and profound words. But thank you, Tasneem, for your time. So that's the end of our program on on divorce, custody, maintenance, and access to children. I know we may not have dealt with a lot of the issues, but as I said, we can do a program again. And with that, it's Assalamu alaikum wa rahmatullahi wa barakatuh.